nominees. Senator Cantwell.
Thank you, Mr. Chairman. And to the nominees, both of you, what factors would you consider in drawing the line between useful enforcement mechanisms and those that could be harmful to American consumers, producers, and manufacturers? And on the other side of the enforcement authority, obviously, is protecting U.S. IP against foreign importers in Section 337 determination, what weight should be given to that public interest standard. If you could answer brief comments on both of those.
I'll start with respect. I'll start with the 337 because that's the background that I come from, and my views on the public interest, based on the way the statute's written and the precedent that was created at the commission, is that we talk about public safety, welfare, and impact on third parties, but typically the issue boils down to whether third parties are going to be harmed if a remedy were to be issued against an entity that was found to engage in unfair trade practice, i.e. Infringe a patent or copyright. And it typically boils down to whether there are alternatives in the market to the item that's being excluded, such that the third parties are going to be harmed because, for example, it could be a component in some larger device or something like that. And so,
do you think we need more clarity here? I mean, you've seen a lot of cases. Do you think we need more clarity here?
Any guidance that would, obviously the commission doesn't make policy, any guidance that we could get from Congress on this thing would, in my view, would be welcome.
Thank you.
I agree with that sentiment, Senator. As you know, in 337 cases, the remedy can be tailored, and so that also is a factor. Depending on the individual facts of the case, you can have an exclusion order, but the commission also has the authority to issue cease and desist orders or to grandfather in, let's say, a component that's already in a lot of devices, and then just prohibit future importation of that component. So there are ways to incorporate the public interest that's not a full, we're not going to take any action at all. But of course, American intellectual property is extremely valuable, and having a law in place to protect our innovators and our innovation economy, I think, is very important. I can speak to Title VII if you would like, or I didn't.
Yeah, that was a big open-ended first question.
Okay.
But it kind of reminds me of this place. Like, we can argue and say we're not going to agree to something, and just, we can be in a conference and then just say we're just going to walk away and we're not going to deal with that issue. But when you do that in trade, sometimes the issue is never resolved, and the businesses, in our case, in Silicon and Moses Lake, a plant shut down because we had a dispute, and nothing was resolved for 10 plus years. Thank God the company's reinvented itself in a different way. But the point is, where do you draw the line between getting into, what standards are you looking at before you look at tariffs? What kind of thoughts do you have about this?
Well, Senator, I think it does depend on the statute. In Title VII cases, as well as Section 201, the commission rules on material injury, right? So the statute's very clear on the factors that the commission can and cannot weigh. So as a commissioner, if confirmed, I would stick to the text of the law in those areas. It's a little bit different in 337 cases where you do have 4 fairly broad public interest factors. And my understanding, though, is that public interest determinations have not overruled essentially an exclusion order in many cases.
Yeah, thank you. Mr. Common, do you have any comments on this? Because I can guarantee you every day I'm offended sometimes with what the other side does, but I don't walk away.
Yeah. The only thing that
I try to resolve the issue. And I just feel like in this world of a global economy with so many consumers living outside the United States, I hear what you're saying. You're basically saying, I'm just going to follow the text and I'm going to be very specific. But this is going to be a very big issue moving forward. And the problem is then when we just walk away, we're not getting anything done. So the question is, how do you digest this when there's so much intertwined now? And how do we get to the real issues? I think IP and IP theft is a real issue.
Yes, I absolutely agree. Of course, Senator, you raise a good point. And yeah, I've seen that in my private practice as well. And the only thing that I would add to what Ms. Craig said is that, you know, if I'm fortunate enough to be confirmed, I would welcome the opportunity to meet with you and your staff to understand better the concerns that you're raising today and try and see if we can figure out ways to move forward.
I'm just saying, I'm pretty sure this is going to be the issue du jour in 2025, but as a very trade-dependent economy, I'm just saying it's easy to walk away from the table. It's easy to push back and say, we're in a dispute. The question is, you know, is that where we want to be in what are the best practices? I personally think we should have a international, you know, organization, if you will, a tech NATO. I think the 5 most sophisticated countries in democracy should get together and say, if you want to buy technology, buy from these countries. Don't buy from countries that have a government backdoor. Don't buy from countries that don't respect intellectual property. Don't do this. And that would be a bigger behemoth in the international marketplace to say, follow these principles, follow these technologies, as opposed to just getting into a trade dispute that doesn't resolve this. We want to use our might where we can use our might. And I'm not saying don't ever use them. I'm just saying, to me, I think we have to think of some new strategies going forward. But thank you, Mr. Chairman.
Heaven forbid there be such a logical approach. And Senator Cantwell